logging on to www.savecockpitcountry.org.
Resumes its sitting. And before we do that, I see we have some members of schools attending with us. Is that micro pre-university program students? Wonderful. We are pleased to see you. And you're always welcome here. This is your Senate. We're pleased that you're so young because you have a long time to be able to carry the message forward. We expect to be on our absolutely best behavior today as a Senate so that we can... Now, best of course depends on interpretation. But we hope that whatever it turns out to be, you will be educated some, you might enjoy it, and we're especially pleased that you're sharing some of your time with us today. Welcome. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following Minister Paper numbers 73 to 75, entitled Cabinet Agenda Issues for the dates 22nd and 29th July 2019 and 26 August 2019. Annual Report and Audited Financial Statements of the Port Authority of Jamaica for the year 2016-2017.
Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House of Representatives to the Honourable Senate. I have the honour to advise the Honourable Senate that on the 22nd day of October 2019, a bill entitled An Act to Amend the Proceeds of Crimes Act was passed in the House of Representatives. Signed Pernell P. Charles, CD, JP, MP, Speaker of the House of Representatives.
Mr. President, I signify my willingness to take charge of the bill.
A bill shortly entitled The Proceeds of Crime Amendment Act 2019, read a first time.
Mr. President, I beg to give notice of second reading of the bill. I further beg to give notice that at a later stage today, I will move for suspension of standing orders to allow me to take second reading of the bill and to take it through its concluding stages.
Papers. Reports from committees. Notices of motions given orally. Senator Brown.
Thank you, Mr. President. Mr. President, I wish to give notice that at the next sitting of the Senate, I'll move the following motion. Whereas it is desirable to encourage fathers to be fully involved in the lives and upbringing of their children, and whereas it is most beneficial if the bonding of fathers and their children commence at the earliest stage of the child's life, and whereas several countries have established paid paternity stroke family leave as a right for employees, And whereas some Jamaican employers are already implementing paternity leave at the workplace, and whereas several Jamaican trade unions, consistent with global progressive thinking, have called for the enactment of paid paternity leave under Jamaican law, be it resolved that this Honourable Senate express its support for paid paternity leave to workers and call for this to be enacted as a statutory right. Be it further resolved that the Senate establish a select committee to meet and receive submissions from the public which will inform government policy and future legislation. May it please you, sir.
Motions that may be made at the commencement of public business requiring notice. Motions for leave to introduce bills. Presentation of bills without leave of the Senate first obtained. Public business.
Mr. President, I now move for suspension of standing orders to enable me to take second reading of the bill and to take it through its concluding stages, notice of which I gave earlier.
Those in favor? Those in favor? Those against? The ayes have it.
Thank you, Mr. President. Mr. President, today we will look at three bills which make up a suite of anti-money laundering, counter-financing of terrorism legislation, which may all be viewed as containing companion measures. The Act to amend the Terrorism Prevention Act 2019 and the Act to amend the United Nations Security Council Resolution Implementation Act 2019. Those were both tabled last week. And I had asked the Parliament to informally circulate the Act to amend the Proceeds of Crime Act 2019 and, of course, asked senators if they would review same, given the importance of the bill and the timeline which we have to meet, that it would then be taken today together with the TPA and the UNSCRIA. So I'm proposing today, in the interest of time, in the interest of efficiency rather, as well as to underline the complementary nature of the bills before us, to just do one general opening and then to deal with the clause by clause for each, and of course then recommend that all three be put to committee after the debate. And I hope that this will work well for all members. Mr. President, none of us in this House, of course, have to be reminded of the fact that getting to the root of crime means that you have to get to the root of the financing of organized crime. And none of us also need to be reminded that our law enforcement efforts need to be strong and they need to be supported by a strong legislative framework. We've always taken a strong stance regarding our role in combating global terrorism and the financing of terrorism. And the bills before us today seek to address all of these. Beyond that, the bills before us are, as importantly, and perhaps more so, depending on your perspective, they're geared at protecting our financial systems and our economy by ensuring our compliance with certain international obligations. So we know that the three principal acts were passed in different years. The POCA was passed in 2007, amended several times, most recently in 2016. And the TPA was passed in 2005, also amended recently in 2016, while the UNSCRIA was passed in 2013, and this will be its first amendment. The Proceeds of Crime Act, of course, the POCA, provides primarily for the investigation, identification, and recovery of the proceeds of crime. And the amendments seek broadly to strengthen the regime which exists. The amendments to the Terrorism Prevention Act seek to ensure the country's compliance with international obligations as they relate to international terrorism, as well as to ensure its alignment with the provisions of the POCA. The amendments to the UNSCRIA seek to support adherence to the UN Charter and implementation of UN Security Council resolutions related to money laundering and the financing of terrorism. Its provisions will also seek to be aligned with the Proceeds of Crime Act. So while each one has its specific context and focus across the piece, amendments to all three are intended to ensure Jamaica's compliance with the FATF, CFATF requirements, as well as AML and CFT requirements on which we are assessed from time to time. So to decrypt some of the acronyms, of course, the FATF is the Financial Action Task Force, which operates internationally in respect of the anti-money laundering regimes. And the CFATF is the Caribbean grouping. It's a regional body comprised of 25 member states of the Caribbean basin, of course, including Jamaica, which have agreed to implement certain countermeasures to address the problems of money laundering, counterterrorism, and the financing of the proliferation of weapons of mass destruction in the wider Caribbean. FATF does all of this at the international level. It, of course, is charged and has particular powers with the issuance of international standards on combating money laundering and the financing of terrorism and proliferation. So as a member of the CFATF, Jamaica is regularly assessed on these standards that I just named. And the most recent assessment took place in June 2015. The resulting mutual evaluation report, the MER, contained certain findings and certain priority actions and a comprehensive list of recommended actions. And that was issued in January 2017. Jamaica was found to be partially compliant or non-compliant with several of the FATF recommendations, and that finds us here. So in the 2-year period which would have passed between the MER and where we are now, actions have been taken. Not only did we seek to push back against some of the findings, to reassert that we thought that we were compliant in this regard or that regard, as against what they had found in their recommendations. We've also sought to ensure that we were bolstering our technical and operational abilities to enforce the provisions which were in place, which would, of course, help us with compliance as well as move us forward. And some of that has been done in cooperation with international partners. So that time now takes us to this place where we must enact the legislation before us to address these gaps by the end of this month to avoid being placed in the FATF's follow-up process. And this follow-up process is a specific designation which would have us recognized, or seen rather, as a high-risk financial jurisdiction, a high-risk financial system. And this, of course, must be avoided at all costs. But the timeline, that is passing these laws by the end of this month, which would require taking these all through their closing stages today, would allow us to seek a re-rating within the FATF's May 2020 plenary, once we meet 2019 deadline. We will have addressed the 2017 MER through the provisions before us today. So essentially, what we are seeking to do today is to not only strengthen our own systems to ensure that we are dealing with our regulatory regime for our own national benefit, but we are also, of course, seeking to ensure compliance, which offers its own level of protection of the financial system. Not to overstate the point, but certainly were we to have an unfavorable designation or not be in a position to seek a re-rating, this would, of course, affect investment, it would affect trade, it would affect the transactional costs between our banks and international banks. There are brother and sister countries that are experiencing that right now, and it could, of course, get worse. The point of correspondent banking risks and the de-risking that is taking place within the international financial system would also be, have us in an unfavorable position. It would intensify the risks in that regard. And this, of course, is something which we have been speaking about consistently across the Caribbean how it is that the de-risking regime, which does not look at the unintended consequences that would occur should small economies like ours be unable to participate in the international system. The concerns, of course, are largely falling on ears which do not wish to hear. What they wish to hear is that we are complying. So even as we advocate for a broader consideration of our plight as a Caribbean, the fact is that we are taking steps here nationally to ensure that we safeguard our systems. Mr. President, with that I wish to start addressing the individual bills, and I will start with the Proceeds of Crime Act. As indicated, Mr. President, there are matters which cut straight across the piece in these bills before us. And I've set out the framework with which essentially we are seeking to comply. The Proceeds of Crime Amendment Bill 2019 before us seeks to do, among other things, and I'll just give a broad headline, to facilitate enhanced or simplified, so both, this is not only about, the work today is not only about strengthening, but it's about also making it more equitable and able to deal with, create an appropriate framework, a balanced framework, although a very strong one, so that it will facilitate both enhanced and simplified customer due diligence on the basis of proven risk of a customer, so that you won't have to apply the same measures to everybody, which is of course deeply burdensome. It would be that you would be seeking to assess the risk within a particular framework so that you can be more targeted and more efficient in your conduct of due diligence. It will address the application of enhanced customer due diligence or other countermeasures for businesses or transactions from countries identified by FATF as having weak anti-money laundering systems, which is the type of system we do not wish to be designated as. So these countermeasures could include restricting transactions with such businesses or with customers from those listed countries to ensure protection of our local system. It will include a general increase in penalties, including in relation to bodies corporate in particular, to make sure that the penalties are sufficiently dissuasive. They are not currently, and this is one of the major concerns which the CFATF found. The introduction, in fact, of a fixed penalty regime on financial institutions for certain technical anti-money laundering breaches. The maintenance of comprehensive statistics that will reflect the overall effectiveness and efficiency of our anti-money laundering regime, particularly in respect to investigations, prosecutions, and convictions. Mr. President, if we look at Clause 2, some of the amendments provided actually cut across the piece. So, for example, there is a provision which ensures that financial institutions include persons who carry on life insurance business, as well as insurance intermediaries in respect of life insurance, but they don't include insurance consultants or adjusters. And this proposed amendment reflects the realities within the insurance sector based on a thematic assessment that was conducted by the Financial Services Commission, because the view was generally that general insurers, they wouldn't be subject to the full range of anti-money laundering requirements because the risk of being able to launder money through general insurance is actually quite low. Brokerage, life insurance, these are areas of sensitivity viewed internationally, and therefore they are being focused on. So this is actually an amendment that follows through the bills before us today. The amendment, again in 2, also clarifies the definition of enforcing authority insofar as the POCA is concerned. and it really just aligns it with the specific jurisdictions of the FID as opposed to the DPP. Clause 3 deals with an amendment to 91A2 of the Principal Act, which speaks to the functions of the competent authority. 91 big A2, sorry, I should say, 91 big A2 of the Principal Act. And it seeks to include a new provision permitting the competent authorities to apply the risk-based approach to AML CFT supervisory efforts, as I had referred to earlier, and is part of the regime to increase applicable penalties. So competent authorities would be expected now to continually assess the risks relating to their regulated entities and to dedicate their regulatory resources and tailor their examination and other supervisory activities to the risks as assessed. So it's no longer at large. This is now more clearly defined and should therefore be more effective. Mr. President, Clause 4 seeks to amend Section 94 of the bill, of the Principal Act, and in this regard, Mr. President, it speaks to the record-keeping requirement that is being imposed, and this is in respect of businesses within the regulated sector. So they must now make and retain for a period of not less than 7 years, which is generally what the requirement is for tax, etc. in any event. So it is a reasonable approach within the framework and one which is aligned with the broader international requirements of which I spoke earlier. So this is about making and retaining records which of course allow for appropriate treatment if anything untoward is found. Mr. President, Clause 5 speaks to the insertion of a new section in the Principal Act, and this is the insertion of 94 big A. And here it is, a section which speaks to countermeasures in respect of companies that are domiciled in listed territories, so territories that have been listed by the FATF. This amendment, this is 94 big A, will ensure application of enhanced due diligence measures for transactions and business relationships with these countries that have been listed by FATF as having AML or weak AML CFT mechanisms, and this is of course in compliance with the FATF recommendation. The goal, Mr. President, is to ensure that all financial institutions adopt international standards to prevent, detect, and punish money laundering, and thereby effectively cooperate internationally through national implementation in the global fight against money laundering and the financing of terrorism. Mr. President, I would just note for information that as at October, countries that would fall within this category are Iran and North Korea, for example. But there are countries much closer to home which are on the monitoring list, and this is a list off of which we seek to remain. Mr. President, Clause 6 deals with amendment of Section 97 of the Principal Act, which speaks to the offense of tipping off. And this offense is being expanded so that it actually is triggered at an earlier stage of the crime. So now it's based in knowledge, and it remains based in knowledge, in knowingly disclosing information. But now it will relate to disclosure of information that would not yet have formed a part of a suspicious transactions report. So it might be at the point of preparation of the report. So there is reason to believe that if it is disclosed, it could compromise the investigation, but it is not at the stage where it is covered by our existing legislation. So the language is being expanded, Mr. President, to allow for tipping off to occur earlier, for the offense to be triggered earlier. Clause 7, Mr. President, amends Section 101 big A of the Principal Act in two ways. Firstly, it changes the reference to goods to property. So instead of looking at transactions in relation to goods and services, it would now be property and services. And this is because there has actually arisen in practice a concern as to whether goods would cover all of the transactions which should be covered, like land and like securities transactions, which would have tangible representation, but would still not necessarily be covered by the normal meaning of the word goods. Secondly, Mr. President, it seeks to strengthen the process of granting exemptions under this section. So again, this speaks to the balance that I referred to earlier. In this section, it would now become a requirement for the competent or designated authority to provide an assessment of the strength of an applicant's money laundering system to the minister for the granting of exemptions to a person or to a particular type of transactions. How the Act is worded now, the minister in the public interest may make an exemption, but there is no inclusion of the FID in that process or any other authority, as a matter of fact. But the amendment now allows for that, for even the minister's consideration of the public interest to be in the context of the recommendation or the assessment by the FID. So there's no an objective process which would allow for a more robust and greater certainty in the minister's exercise of his discretion, or hers, of course. Clause 8 amends Section 102 of the Principal Act, Mr. President, and this deals with the power of the minister to make regulations. And this is expanding the language to ensure that it can address regulations, or rather that it will permit regulations related to the application of enhanced monitoring procedures in respect of specified territories, to which I made reference earlier. So this links right back to 94 Big A, the new section being included. Clause 9 amends Section 137 of the Principal Act, which deals with the protection of persons exercising functions under the Act. So again, this is something that has been encountered in practice, which is that the language does not necessarily encourage the participation of the enforcing authority and the competent authority, because the protection is not expressly there, although one would understand it to be. So there is no express provision to ensure that the persons enforcing who treat with these types of reports are protected. No civil liability shall attach to them in the appropriate conduct of their work. Mr. President, Clause 10 amends Section 137. It in fact includes a new 137 Big A, which deals with the statistical information in a more detailed way. It speaks to the role of the supervisory authority, the competent authority, and the designated authority in keeping the statistical records required as appropriate to ensure the effectiveness of the measures provided in the bill. And this is one of the recommendations under the CFATF, although I'm not identifying all of them. Sometimes it bears mentioning for emphasis, Mr. President. And this actually also speaks to the sharing of information with certain entities, and these entities are named: the DPP, Commissioner of Police, Commissioner of Customs, Attorney General, Director General of MOCA, and the CTD of the FID, and any other designated authority under the purposes of this, for the purposes of this section. And that is only done, of course, where the details that are shared do not disclose an individual, Mr. President, or permit identification by reasonable inference. It's actually quite an effective provision, protective provision for sharing. Mr. President, Clause 11 amends Section 138 of the Principal Act, which deals still with regulations, but it speaks here to the penalty regime. Mr. President, it was felt that there was significant need for the ability for the enforcement, effective enforcement of any anti-money laundering regime. Internationally, it is viewed that a robust sanction regime, penalty regime, is important. If an organization does not feel it in its pocket, when its very raison d'etre is monetary, as you know, money laundering is, at the risk of stating the obvious, then it is by nature ineffective. And therefore, a new penalty regime is being introduced on recommendation, and that is what is provided for here. So it is hoped that these sanctions would operate as dissuasive measures to promote compliance without threatening financial sector stability. So without imposing a criminal liability on a corporate entity or a banking entity for having had a breach, you would make it hurt, dissuade it, but you wouldn't compromise your financial system by attaching criminal liability to the entities. Mr. President, Clause 12 inserts a new Section 139 in the Principal Act, and this complements this section to which I just spoke, again in compliance with the CFATF recommendations. It states that these penalties, while they must be dissuasive, they must be proportionate, and therefore this section, this new Section 139, actually provides the elements that should be considered by a court in applying the penalty. So the nature of the business carried on by the body corporate, the size of the business, including the level of profit or total revenue generated by the corporate body, and any other factor that the court considers relevant should be considered when a penalty is being applied. So again, this is about appropriateness and balance and ensuring effectiveness. So, Mr. President, the poker is recognized by the government as an important tool in the fight against organized crime, and therefore we are seeking to ensure through these proposed amendments that there are appropriate safeguards to guarantee the integrity of our financial system. Mr. President, this takes me to the Terrorism Prevention Amendment Act. And Mr. President, I've already spoken to the CFATF and the FATF framework, the MER provided in 2017, but also in 2017, Mr. President, we received a mission from the United Nations Counterterrorism Committee, and this was in March 2017. And this CTC is a body established under the UN Security Council Resolution 1373, a 2001 resolution to oversee the implementation of Security Council resolutions, and it is supported in its work by the Counterterrorism Executive Directorate. So this directorate, this committee, paid us a visit in 2017, and they indicated thereafter that they had some recommended amendments, or rather measures, which we needed to take in order to be compliant, to have an effective regime, and these are being implemented in addition to those which are required for CFATF, where there are no overlaps, and there are overlaps as well. So, Mr. President, this bill provides for the express prohibition of incitement to commit terrorist acts. It also criminalizes the financing of the travel of foreign terrorist fighters and the travel itself of foreign terrorist fighters in accordance with UNSCR 2178. So it's, if you're paying for a foreign terrorist fighter to travel, or if you are providing the means of travel, both are offenses now. And there is also provision for the creation of an offense whereby they are leaving to go to a terrorist, a listed country, a listed jurisdiction, so that the offense is not only committed there, an offense is committed if they are facilitated to leave. They commit an offense by leaving to go to a terrorist listed jurisdiction. So again, this is a broadening and a strengthening of our regime, which is, this is one of the ways in which we are not compliant with the international existing regime. It did not, the amendments we made did not go far enough in the assessment of the global regime. So this is, and we know this is a particular issue within this region as well, the restriction of foreign terrorist fighters. So this is something we are committed to ensuring is absolutely strengthened in every way we are able. Mr. President, the bill further makes provision for the prompt freezing of funds or other assets of persons designated as terrorist entities without delay. That is from the time of communication of the designation to the relevant entities, and the exemption of persons from civil liability on their compliance with the prohibitions against dealing with terrorist property and undertaking all reasonable steps to satisfy themselves. So again, this is one of the protective measures. All of them are not, punitive measures. Some are protective, as I mentioned earlier. This also speaks about, Mr. President, the publication of the listing of designated persons on the websites of the DPP, the FID, the BOJ, the FSC, the ministry with responsibility for the TPA, that's the Ministry of Foreign Affairs and Foreign Trade, on the same day as the granting of the order by the Supreme Court, provided the order is granted by the end of a working day. And where the order is granted too close to the end of a working day, the following working day. And I did check, Mr. President, the website of the Ministry of Foreign Affairs and Foreign Trade this morning. It is not only up and running, our sanctions listing is present and easily identified on the home page. So for everyone who is interested, Mr. President, this also provides for an order to be made to the relevant UN committee to delist an entity. This is something that our regime did not provide for. It provided for the listing of entities, but it didn't provide for one to be delisted if circumstances had changed. So this is now being proposed. And it also allows for us to submit the names of persons or entities for designation to the relevant UN committees for ISIL, Taliban, and Al-Qaeda listings. Mr. President, the relevant authorities, that is the FID and the DPP and the Commission of Police, are now able to jointly make a recommendation to both the Minister of Foreign Affairs and Foreign Trade and the Minister of National Security on whether to submit such a designation, such an entity for designation as a terrorist entity to the UN Security Council Sanctions Committee. Mr. President, this bill also provides for the expansion of the offense of tipping off to align with the enhancement that's also being done under the Proceeds of Crime Act. So, Mr. President, here there are amendments which address in Clause 2 the references to competent authority and designated authority. They are now to be found in Clause 2 of the Act, Section 2 of the Act. Financial institution is also aligned with the POCA, as indicated earlier by the inclusion of life insurance operators, and again aligned with POCA. It amends the definitions of the terrorism offense and terrorism activity to include incitement and the attempt to commit. Mr. President, Section 4 of the Act, that is in respect of facilitating, the meaning of facilitating terrorist activities, it is now being clarified to tie it directly into Section 8, subsection 2 of the Principal Act, which stipulates that a terrorist activity is facilitated where the facilitator knows that a terrorist activity will be facilitated, whether the facilitator knows the specific nature of the terrorist activity and whether the terrorist activity is actually carried out. So that's there in the Principal Act, Mr. President, but this is intended to expressly ensure that the meaning of facilitating a terrorist activity is extrapolated and applied throughout the Act to ensure clarity of the offense. Mr. President, Section 6 more expressly speaks to the ability to provide exemptions for an order. Right now, Section 6 simply says that no person may knowingly deal with directly or indirectly any property that's owned or controlled. But now this provides for the exceptions which can be made under 14B, 14.4 big B, and it now will provide except as permitted by exceptions set out in an order under Section 14.4b. So there's a broader provision again to allow for equity. Mr. President, Subsection 1A of Section 6 is being amended to include the words "or derived or generated from property owned or controlled by or on behalf of a terrorist group." So this is expanding the scope of the provision so that an offense will be created not only when property is knowingly dealt with that's owned or controlled, but where it is also known that the property is being dealt with by a company which itself is owned and controlled. So it is going one step behind, Mr. President, to ensure that there's no technical compliance that allows for, and that's technical not in the good way, but technical compliance which allows for someone to say that they didn't commit an offense, but they knew. It's just that the company was not the actual offender. It was owned by the terrorist entity or listed entity. Mr. President, subsection 1C of 6, section 6 is also amended to provide for the reference to property, and it therefore would now be aligned with the arrangement spoken to earlier under POCA. This is now referring to property that has been derived or generated from property owned or controlled on behalf of a terrorist group as well. So this is, again, broadening the effectiveness of the TPA. And subsection D, Mr. President, is exempting persons from civil liability, provided that they comply with prohibitions against dealing with terrorist property, and they took all reasonable steps. Mr. President, Section 7 of the Principal Act seeks to conform with Security Council Resolution 2178, which sets out the actions to be taken by states to combat some of the risks posed by FTS, including their movement across national borders and financing of their travel. So this is dealt with, Mr. President, in subsection 3D, and in, Mr. President, in section 8, which is being amended in subsection 3. The amendment seeks to clarify the facilitation of terrorist activity, as I referred to earlier, and the amendment seeks to extend the facilitation to include leaving or attempting to leave Jamaica in order to facilitate or commit a terrorism offense, or providing any financial or other services to facilitate. Mr. President, the amendment seeks to conform with paragraphs 1 and 2 of Security Council Resolution 2178, which has much broader provisions. So this is really only seeking to deal with paragraphs 1 and 2 for compliance. Mr. President, Section 14 of the Principal Act is the amendment which deals with the expanded circumstances within which the DPP may apply to the judging chambers for an order to declare an entity to be a listed entity. And it also provides for the provision of an order, for the seeking of an order to contain a prohibition against dealing with properties to be used for terrorist purposes. Mr. President, the new section 14.4b has introduced the exceptions to freezing or listing pursuant to Security Resolution 1452. And, Mr. President, this is in alignment with specific circumstances that are provided where limited access may be allowed to these funds. So these include where access is necessary for basic expenses, payment of reasonable professional fees, fees or service charges for routine holding or maintenance of frozen funds, or meeting any extraordinary expense which the judge thinks fit to allow. So this is again important to ensure balance and equity in the type of order which the court can apply, and it is again aligned with our existing legislative framework and our obligations. Mr. President, the new subsection 14.4 big C stipulates the exceptional circumstances under which the judge will allow the listed entity to deal with property, which is the subject of the application. And again, this, well, I won't go into the details. Subsection 14.4d indicates that where an order is made to list an entity or to revoke a listing, Mr. President, the ministry responsible for foreign affairs and every competent authority and designated authority shall cause the order to be published within 24 hours after the order is made. And Mr. President, the good thing is that the time that's been used between 2017 and now has brought us to a place where we are actually broadly compliant with the 24-hour regime, so that now that it's being expressly stated in the law, we will be compliant. It won't be about coming up to speed now. We have actually done the work, and so that this will now ensure enforcement of a practice, or operation rather, which is now in place. Mr. President, in the current 14.5 has been amended to delete the reference to publication of the order within 7 days after the date of the order, because this has been replaced by the regime which I just made reference to, that is the 24-hour period, and again this is required by FATF. There's also a further obligation to include with publication, to also undertake a publication within 7 days of the end of each calendar quarter of all of the orders which have been issued within that quarter, and that this will be reviewed every 6 months. Mr. President, Section 14.6 will be amended to indicate that within 60 days after the publication of an order, the entity in respect of which an order is made may apply to a judge for a review of the order, and they must notify the DPP, but this is, again, allowing for the party, the subject of the order, to have the matter reviewed. This was not in place before, and 1419B provides for the duty of the DPP to review all orders to determine whether the circumstances under which the order had been granted had been changed. This is actually an existing provision, Mr. President, but it provides for that to be done every 6 months. It's now to be done every 2 years, which again was a recommendation, and one which also has the added benefit of efficiency in light of resource constraints and the time that these things necessarily take. Mr. President, 1410 stipulates that if a judge is satisfied with the application as grounded, he or she, that is a revocation or renewal, he or she may grant a requested order. And 1411 addresses the provision of an order for domestic listing which has not been revoked or renewed. It provides, Mr. President, that those shall expire 3 years after the date on which the order was made, unless there is grounds for renewal. So you can't just, if you are able to successfully apply for a domestic listing, then if nothing changes and the state has not done anything, the order itself will expire. So again, this is equity, and it is again UNSCR 1373, which provides for domestic listings, and the regime that we implemented here was after examining what is done in countries like Australia, New Zealand, and Canada, where they do also grant us a longer period, so 3 years here, as opposed to the 2 years that's required for the DPP's review of international listings. So this is a domestic listing regime, making sure that equity prevails. Mr. President, subsection 12, of course, also provides for the DPP to apply for an order to relist entities where the previous order has expired and the circumstances so justify. Mr. President, and 14B provides for the designation of terrorists to the relevant, by the relevant UN Sanctions Committee. And this is actually quite a robust designation provision. It's the point I referred to earlier, whereby there is a written recommendation from the Chief Technical Director of the FID and the Director of Public Prosecutions, and it is made to the Minister responsible for Foreign Affairs and the Minister responsible for National Security, where there are reasonable grounds for making the designation, and that it has been done in accordance with the criteria established by the relevant UNSCR. So it has to apply, it has to comply rather with the criteria set out in the Security Council resolution, and it must be made to the relevant sanctions committee of the UN, and it is done, however, where the entity is in fact Jamaican. So it is about a local designation to the international, that's made, considered by the international committee. Mr. President, the amendment of Section 16 of the Principal Act is also treated with by this bill, and it seeks to introduce record-keeping requirements similar to those which have been introduced to the POCA. That is, again, the 7-year period in respect of complex transactions, unusual or large business transactions carried out by a customer with a reporting entity, unusual patterns of transactions, whether completed or not, which appear to the person to be inconsistent with the normal transactions. So again, this is about record keeping. The new subsection 3, Mr. President, the Act's former subsection 3A, because that is to be deleted, it imposes a duty to report. It imposes a duty to report all to the FID all of these transactions which it has reason to suspect involve property connected with.
The minister's time having expired, may I ask that it be extended to longer?
Aye.
Thank you very much, Mr. President, and thank you, Leader of Opposition Business in the Senate. Mr. President, there's one thing to note, that we do have a small amendment in the bill, and that is in Clause 3. There is, just for avoidance of doubt, we're not going to treat it as a typo. We are going to be clear. This is the amendment to Section 3. Oh no, I'm in the wrong bill. This was handed to me at the wrong time. My apologies. I was destined to have at least one of those. Okay. Mr. President. Yes, I'm still in the Mr. President, consequential amendments have been made to several subsections. So subsection 4, which has been made to comply with subsection 3. Subsection 5 has been amended to provide that somebody may have a defense of a reasonable excuse for not making a report. That didn't exist before. To a charge under subsection 3, and subsection 7, which provides for the exemption of employees and directors from criminal prosecution, civil and other liabilities where a report has been made under subsection 3. And again, so it's a protective regime that I referred to earlier under POCA is replicated here. Mr. President, there's a new section 16A also included, which implements the risk-based approach to monitoring and supervision required by the FATF. So it addresses enhanced monitoring in respect of transactions with customers domiciled, resident, or incorporated in specified territories. And it further defines the enhanced due diligence measures referred to, and clarifies, or rather defines, that a specified territory is a territory specified in a list published by notice in the Gazette by the designated authority as being a territory in respect of which there is a greater associated risk of money laundering or terrorist financing. Mr. President, Section 17 of the Principal Act is amended also. This section deals with the offense of tipping off, and more particularly, again, this is aligned with the tipping off also under POCA. It is being widened to include circumstances in which a person acts where he knows or suspects that the report or the disclosure is about to be made. So it has a preventative measure as well. Mr. President, Section 18 is amended by deleting the words complex, unusual, or large, and substitute same with the word suspicious. This is in line with the amendments being made to paragraphs 2 and 3 of the Principal Act. paragraph, section 2 and 3 of the Principal Act, and which relates to complex, unusual, or large transactions and only refer to suspicious ones. Mr. President, insertion of a new section 18A and a new section 18B, which address the new functions of the competent authority. And here, Mr. President, there is one amendment to be made, and this is that in the new section 18 big B 1, the word supervisory authority is going to be deleted. So an amendment to the amendment proposed. The supervisory authority exists under POCA, but it doesn't exist here. You only have the competent and designated. So it will be removed from 18 big B 1. Mr. President, 18B, of course, is a section which refers to all of the statistical requirements to support the overall effectiveness of the
Just
measures.
one query, just to make sure the two words supervisory authority will be removed
Yes.
from 18B1.
Yes, so that is clause 13 of the bill. Clause
Right.
13 of the bill.
That's right.
Yes, thank you, Mr. President. And the final amendment to be proposed in respect of the Terrorism Prevention Amendment Act 2019 will be in the schedule of the Principal Act. And this will be to the definition of BCN weapon, where the words in types and in quantities consistent to those purposes will be moved from subparagraph big D and moved to the margin of paragraph B for the definition. And when you reread that, you will understand the necessity for it. It was actually a drafting error in the first bill that had been missed, in the Principal Act, rather, and it is now being corrected at this time. We're going along well, Mr. President, and as we move into the UNSCRIA, that is the UN Security Council Resolutions Implementation Act. Mr. President, here again, the Principal Act, which was promulgated in 2013, was intended to ensure Jamaica's implementation of resolutions under Chapter 7 of the UN Charter and to fulfill requirements of the CFATF. These amendments proposed today are required to take us further along the compliance path, and a very important compliance path. Mr. President, the amendments that have been put forward before us start with Section 2, which provides, again, for the new definition under financial institution in paragraph E. Again, this includes the life insurance business and insurance intermediaries regarding life insurance, but excludes insurance consultants and adjusters, as with POCA and the TPA. Amendment of Section 3 of the Principal Bill, and here we are in particular treating with subsection 1 to empower the Minister to make regulations to give effect to decisions of the UN Security Council in accordance with our international obligations under the UN Charter and the FATF recommendations. So the prompt implementation of resolutions dealing with issues, the specific period of 30 days after the resolution or as soon as possible was introduced for the enactment of implementing regulations. And this is subject to the proviso that the decisions do not require Jamaica to apply any measures which involve the use of force. And this is again also consistent with the provisions enshrined in the UN Charter. Subsection 2, little f, little a, provides for the giving effect to Security Council resolutions which allow for the protection of bona fide purchasers, that is bona fide third parties who act in good faith in dealing with the assets of proscribed persons or entities. This protection was not included in the bill before, in the Principal Act, and now this protection is going in for bona fide third parties who act in good faith. Mr. President, subsection 2 big A will also further stipulate that where the relevant Security Council resolution provides that the withholding of assets of persons or entities that have been prescribed by regulations may be subject to exceptions. So again, now it's allowing for more targeted approaches. So the implementing regulations must contain provisions which explicitly articulate the exceptions, and subsection 2B, 2 big B, declares that where they provide for exceptions, they must not take effect unless the relevant Security Council Resolution Committee objects, that is, unless the minister receives such objection, and then the minister may proceed to bring the implementing regulations in relation to the exceptions into operation. No, until after. Yes, they shall not take effect.
Unless the objection is received from the
Right. Or until.
You'd have to get the objection from the
You wouldn't implement, it's a double negative, you're right. I think there's a knot in the wrong place. You're right, you're right. So it is, but it is, the intention is that it would be, you are to implement, you can only bring it into effect, rather, the minister can only bring it into effect if the committee does not object. Right. Thank you very much for listening, Minister. Senator, sorry. So subsection 5, big A, mandates that that means I'm going on well too. Subsection 5, big A, mandates that a person or entity that has been prescribed under the Act as a result of a Security Council resolution may submit a request for delisting, Mr. President. And this is to be submitted directly to the appropriate authority. So again, this is a focal point within the UN system, the relevant Security Council Resolution Committee, or the focal point established for delisting further to Security Council Resolution 1730. Sorry, can you just let me a pen 1 second? Sorry, I just want to, because I need to. Thank you. The new subsection 5B, Mr. President, stipulates that where the person or entity requesting delisting is a person in Jamaica or a Jamaican outside of Jamaica, the request for delisting may be submitted through the minister for transmission directly to the appropriate authority designated to address delisting requests. And again, this is within the UN system. The new subsection 6 big A, Mr. President, empowers the minister to amend the schedule of any implementing regulations and to make the relevant consequential amendments. And as we get close to the end, section 3 big A of the Principal Act, Mr. President, provides for the making of an order by the judge of the Supreme Court. And this is applicable where the person or entity has been entered on the list of proscribed persons or entities by a resolution of the Security Council. And subsection 2 will empower the DPP to make an application to the judge to declare a person or entity designated by them as a proscribed person or a proscribed entity. Subsection 3, this is again still in 3 big A, further stipulates that the application of the DPP must be made ex parte, must be accompanied by an affidavit, and pursuant to subsection 4, the judge, after being satisfied by the application, may by order declare. And this order then under subsection 5 must be published on the relevant websites within 24 hours. So, Mr. President, amendment of section 5 of the Principal Act is also provided for by inserting subsection 3 big A and 3 big B. Big A, 3 big A provides that specified entities, including but not limited to financial institutions and designated non-financial institutions, have an obligation to report particular matters to the designated entity. And such matters will include transactions or attempted transactions which are believed or known to be related to a proscribed person or proscribed entity, assets owned or controlled by or on behalf of such persons or entities that are in the possession or control of, among other things, financial institutions or designated non-financial institutions, as well as any breaches of any provision of the Act by such persons or entities. 3B mandates that all reports are to be disclosed to regulators of financial institutions and designated non-financial institutions as an authorized disclosure. Mr. President, new section of 8A of the Principal Act is also being amended, and subsection 1 addresses the subject matter of dealing with the assets of proscribed persons or proscribed entities. This is a freezing provision under this act. We dealt with a freezing provision under the TPA. So specifically, no one should knowingly conduct specified activities in relation to a proscribed persons, and such activities will include dealing with assets that are owned or controlled by or on behalf of or at the direction of the proscribed person or entity, as well as funds which came from such assets, or entering into or facilitating any transaction or providing any financial or related services in respect of such person or entity. Mr. President, subsection 2 provides an exception in relation to civil action where a person had acted reasonably in taking or omitting to take measures to comply with subsection 1. So again, injecting balance into the process. And subsection 3 provides that dealing with assets of a proscribed person will result in the commission of an offense, the penalty for which is a fine or life imprisonment. So serious business, Mr. President. Finally, Mr. President, there is a new subsection 14A of the Principal Act, and this clause provides for the notification of designation and the issuance of guidelines by the relevant authority. So while for the enforcement or implementation of these legislations, one expects guidance notes from the FID or from any other relevant authority, and this has been something that has been produced in the past, but the Act is now expressly requiring it. So there's an obligation to issue guidance to ensure that there is effective implementation and enforcement. It cannot be ad hoc now, it must be done appropriately, and this is something which is provided for across the piece. Mr. President, there will be one amendment to this bill that's provided, and this is an amendment to clause 3. In the amendment to section 3 of the Principal Act at paragraph A, there is to be a deletion of the reference to 3A and its replacement with subsection 2B. So this is a UNSCRI A, so this is clause 3, which under A1 speaks to subject to UNSCRI. So clause 3, which amends section 3 in paragraph A, it speaks to subject to section 3A and subsection 3A. It should actually say subject to section 3A and subsection 2B. So we're deleting 3A, the second 3A, and replacing it with 2 big B. Mr. President, I have sought to emphasize the importance of this legislation, all 3 pieces of legislation, which are required to protect our financial sector, our financial sectors, and the ability of Jamaica to engage with the international financial system in a way that is positive, progressive, and safe and secure, one that not only protects our business but plays our part in protecting the global financial system, which seeks to end money laundering or reduce it, make it too risky for us to be a location for that to happen, as well as, of course, to reduce the correspondent banking risks which we have been experiencing across the Caribbean region. With that, Mr. President, I look forward to hearing the participation of others in this important debate.
Thank you, Leader. Senator Kamina Johnson-Smith. Senator Knight.
Thank you, President. And thanks to the colleagues on the other side. I heard a thunderous applause when it was indicated that I would be speaking. President, there are times when we're allowed to digress a bit. And it's due oftentimes to the solemnity of the subject matter of the digression. And somehow, because of the period during which I pursued my university training, it was during the 60s, the turbulent years when in the United States of America the Black Power movement, as it was known then, took root, and there are certain persons who were participants in that movement. And somehow today I remember Congressman Elijah Cummings, who was a great American politician and member of the House of Congress. And he has passed, and I think today is his funeral. Whenever I turned on my TV to a foreign station and he was on it, I listened to every single word that he said. I really regard him, personally I regard him as one of the participants and heroes coming out of the Black Power movement in the 1960s. And there will be hopefully another occasion when I can speak more fully about my regard for him. But may I just simply say now to his family, his friends, his supporters, his constituents, that celebrate his life. There is much to be celebrated, and may his soul rest in peace and light perpetual shine upon him. Trying to get out of that mood now, let me take on this responsibility to participate in the debate. And I don't know. Each time almost that I come to this Senate, I'm surprised. And today, having heard the Minister of Foreign Affairs and Foreign Trade and leader of government business in this chamber, I am again surprised. But this time, it's a pleasant one. I must commend the minister on the way in which these important bills were presented. That commendation goes to her in her capacity as minister. And then in another capacity, as a member of the cabinet, I commend the government for taking this important step. You know, we have a long history, this country. We have a long history of recognizing that there are global problems which can only be dealt with if there is a multilateral approach to finding the solutions. And these bills and this action today on the part of the minister underscores Jamaica's continued commitment to multilateralism. Because the world faces a threat. And without going into the politics of any particular country, I must say that my own view is, and I'm not singular in this view, that we are today further away from a solution to the problem of terrorism than we were perhaps a month ago. We are further away because of misguided policies, not thought through policies, which have the potential to revive the terrorist threat to the international community. And what we're looking at here is Jamaica playing its role in trying to ensure that the terrorists will not be able to roam free and to pick out what they would regard as soft targets from which to operate. I recall well when this bill was passed in 2005 pursuant to Resolution 1373. Perhaps at the stage we were in a state of fright or shell-shocked or what, but the country did not recognize the importance of the step that Jamaica was taking in the passage of the terrorism prevention. And we tend sometimes to recognize ourselves as an integral part of the international community. But then again, there are times when our thought process tends to isolate us from the international community, and we believe that we are a safe haven, and that terrorism is not something that can affect us. We are wrong. Jamaica as a country is not a target. It's not a target. But Jamaica as a country, if we do not take the appropriate steps, then we will be used to perpetrate acts against persons who come here, because those persons are targets. And I want to just expand a little on it. I don't believe that terrorists are going to come to Jamaica to wage their criminality against the Jamaican society, because our role in the international community doesn't excite that kind of action. But there are persons who visit here who are targets. And therefore, we have to, in our own involvement in this fight against international terrorism, we have to have the legislative framework, and we must also make our citizens aware of the dangers which we face, because we have a tourist industry. We have a tourist industry. And there are tourists from particular countries who are targets. And therefore, if we don't recognize that, and we feel self-satisfied that we are not a part of that community that will face that kind of challenge, then we may find that we do so at our own peril. We cannot not participate in this international struggle and fight against terrorism. And as I said, I get the impression that there could be a revival of this threat. And the revival of this threat has nothing to do with us, but we are exposed to it. We are exposed to it. And so, beyond the passage of the legislation is the importance of getting into the psyche of our people, why we have to do this. Because when it was initially debated in the lower house, there was not a recognition of the need. And you are going to find that in the society today, there are persons who are going to be saying they spend the time passing this kind of legislation, but we are not targets. I won't say it again. Jamaica is not a target, but targeted persons come to Jamaica, and Jamaica could be used by terrorists in order to carry out their dangerous, cruel, and ridiculous type of activity. So commendations flow freely from me to the minister and to the government. And this is where now I introduce another concept. For these bills, I want to just slip in, President, a concept.
Senator Knight, I'm just going to ask you that I ask all our colleagues to make sure they hear exactly what you say. You're in such a good role. I just want them to hear you. So will you please listen to Senator Knight? Thank you very much.
Well, let me tell you, anyone who is disobedient to the words of the president will have me against them. It brings in another concept, which sometimes we lose sight of. This concept of continuity. Because this is a recognition, these bills today, recognize Jamaica's historical approach, and an approach which each administration has adopted. That is multilateralism for a country like us must be at the heart of our foreign policy. That said, the minister made reference to the Caribbean Financial Action Task Force. We had a very important role in the establishment of this task force, and we had the opportunity to have chaired it in its initial stages, and it is out of the Financial Action Task Force recommendations that we passed legislation dealing with money laundering, etc., etc. And I'm pleased that the CFTF continues to play its important role in this regard. I have but a couple of comments to make on the bills themselves, and certainly only in relation to the amendment to the TPA, the Terrorism Prevention. And let me look at page 4. Minister, subject, I'm looking at 4B, clause 4B. Subject to paragraph 4C, the prohibition referred to in subsection 4A may be made subject to such exemption as the judge thinks necessary. And it sets out basic expenses, mortgage, medicine, so on and so on. It deals with professional fees, routine, and other aspects. You know, the one thing that crossed my mind, and maybe it is because I have not looked at the parent statute in a little while. I was thinking of things like school fees. And it came up in my mind. Mike? Oh. Okay. School fees. I'm wondering if this should not be included specifically, even though it says such as, because such as, for example, would naturally, in my view, have included medicine and medical treatment and so on, but yet it's specified. And school fees, and I tell you what, children are persons affected. Let me tell you, it was brought to my attention recently. It's not 100% on point, but I just tell you, it's tangentially related. A Jamaican parent called me to ask for help. What can I do? This distraught father asked me. My son was never left me. don't want to be wrong, never left Jamaica before. He was born in the UK, came to Jamaica as a youngster, and he has lived here all his life. He's now going back to the UK to attend university. They're paying his fees, his school fees. And when the youngster gets to the UK, he goes to university only to find out that the fees were frozen. Frozen. Why? Because they had him in some system where he was a suspect. And the only thing that the distraught father and myself could come up with was the boy's name. The boy's name. You know, so it just, as I read this, I just reflected on that to show how something as simple as that can prevent a youngster from getting, you know, appropriate training in a educational institution. So if we specify, I think we're protecting. If we don't, I believe we might be leaving it open when there is no good reason, and it is more beneficial to specify than not. Sure. Now, I also have another little one on page 7, which is page 7, which is clause. Oh, this is purely editorial, and I don't even know if I'm right. 14A1, line 1, 2, 3, 4, 5. And it's just to put it in context. By the United Nations Security Council, in respect of whom an order is made under section 14.4. Is it of whom or of which? Because speaking about an entity. So I believe so. I mean, I don't want to nitpick. Exactly. So you know, when we pass this legislation, let's, if there's a simple error, let's just correct it. No. An entity. I'm not sure. Well, it just sounded to me that if you say without prejudice to any application for review that may be made under section 14, an entity included on a list of entities designated as terrorist entities by the United Nations Security Council, in respect of whom an order is made. Just don't sound right. But 13. Choice of the draftsman. I'm looking, it's page 13. Well, I have the long version though. I'm looking at what then is clause 18A, and I'm looking at 18A3. Nothing in subsection 2C shall be construed as requiring an attorney at law to disclose any information or advice that is subject to legal professional privilege. I am informed that the Bar Association, that they are a little bit concerned about this. They seem to think, if I have them corrected, that this, in a sense, mirrors the poker provision, and that is seemingly what they're saying. I have not spoken directly to them, but it came to me. And they are saying that that one was challenged, and they are now awaiting the judgment, the written judgment. So this is just a cautionary note. Yes, but it's just a cautionary note to you as minister to say, well, this is something that perhaps before it is signed by the Governor General, that you would ask the Attorney General, because she has to certify the constitutionality of it, that you could ask her to just have a word with the Bar Association. Oh, I don't know. This came to me very, very recently. As a matter of fact, whilst I was sitting here, and so I haven't had. I haven't had the occasion myself to look at it and to even understand fully their complaint. I have another little problem. Nothing difficult. I am at 18.4, 18.5. Right? Where it says now 18, is it A, B? 18A 5. No, it can't be 5. Yes. Yes. Where it says a reporting entity which fails to comply with any requirement or directions issued to it under this part by the competent authority commits an offense and is liable A, on conviction before a judge of a parish court to a fine not exceeding $3 million, or on indictment before a circuit court to a fine. Let me just ask. In the event there is default of payment, what's the remedy? That's my question. Well, you see, usually there is a provision that in default, a custodial, and there are rules as to who would be the officers who would be called on to serve that custodial sentence. What I don't want is a situation, if it is covered, and Mrs. Aldred, as the person, would in a flash be able to tell me whether it is something you should consider. Because one of the things you don't want is that these entities just ignore with impunity, orders of the court. And I think that Oh, here again I'm nitpicking. But I feel able to do so because the leader of government business is in such an admirable mood. This will fall off the bill. I know the memorandum of objects and reasons. But let me tell you, a decision has been taken to amend the Terrorism Prevention Act in order to ensure compliance with Jamaica's international obligations. Yes, but because I feel so strongly about it, I want the people of Jamaica to understand. It can't be. It cannot be.
Mr. President, the senator's time for speaking having expired, might it be extended to allow him to close his presentation?
Those in favor? Aye. Those against? The ayes have it. Senator Knight.
No, this is my final point. Thank you, colleagues. Let me tell you. I am now concerned, as I mentioned earlier, with the psyche of the Jamaican people. I want the Jamaican people to understand this is not an academic exercise. It is not a group of parliamentarians assembled at Garden House who just want to pass laws. And some are going to see parts of this as oppressive, you know. They're going to. But if they understand clearly why we have to do it, it is not just part of our international obligations. It is, Minister, for our own protection.
Yes.
And you made a point there which comes into the international obligation, that if we don't pass this legislation, our economy will be decimated. Jamaica would necessarily become a failed state if we don't pass this. It would. How we would possibly survive in the international community? We couldn't. But that's the international obligation on our own interest. But from the security point of view, that's why I really think that history must record that we understood the importance to us, because there is a tendency sometimes, you know, in the society to say, oh yeah, they passed this because of the pressure from this country and that country. Of course, this is pursuant to the UN resolution. You know, it's not pressure from any uncle or any mother or anything. It is the international community through the multilateral process. And we must remember that we have seaport, airport, aerodromes. We have right across the island, particularly where you come from. You don't come from there, but you live there. In Montego Bay, over in Negril, every day, there are persons there who represent a target. And at all of those locations, they are targets because of the users. And so I want to commend you again for the alacrity with which this has been done. In other words, there's a timeline, and we are recognizing our obligations to the world at large and to our Jamaican people, and we are acting as we ought to. Thank you.
Thank you.
Thank you, Senator Knight. Leader.
Thank you, Mr. President. Mr. President, I must say I'm overwhelmed. But
I
now
fully
we
understand, Madam
have
President.
a full understanding
I
of the
fully
inclement
understand.
weather which we are experiencing. But Mr. President, I am indeed pleased, and there are matters like these that that transcend and that go beyond not only you know, a political divide, but certainly unite us in the space of international imperatives as well as national. And I, as you started to speak about the memorandum, I looked across at my team because I had to sign off on the matter while I was literally going into the air to go to LegCom in order for us to make the time. And when I saw the MOR, I said, what about what's important to us? What about our national imperative? What about the securing of our economy and the robustness of our framework? And we sort of said, well, do we want to open up the bill at this time? But the fact is there are a couple of things, and I think that there is merit in ensuring that we record, that history records that we acknowledged the context within which this bill was being passed. This as well as the Security Council Resolution Implementation Amendment Bill, because that too falls within the remit which allows me that room. So I had asked them to work on some language just because I was so uncomfortable. So I will ask them to pull that forward. We've noted or rather I brought to the attention, 3 or 4 other small minor amendments which we would take, so we could just add that in as well if everyone is minded to support. Regarding the issue of whom, the Act actually specifically defines entity to include a person. So the recommendation is that we leave it as is. And there is unfortunately a concern about the matter in relation to the funds which could be released, because the language that has been used is verbatim Resolution 1452. So the hope would be that if someone had that concern, that they could apply for it to be released under the paragraph that provides for basic expenses, that a court would be minded to consider that. School fee. Yes, and hopefully the such as would allow for a broader interpretation, as I had indicated earlier. So we take one but not the other, and continue to enjoy the pleasant mood of the morning into afternoon. Oh, yes, it's being written, but so far as I understand, the operation of law would provide for it, but let's just get it so it can be on the record. Unless, of course, perhaps we could just deal with it in committee. Yes, could just deal with it in committee. All right, so we will, I might ask Mr. President for third reading of the second reading, pardon me, second reading, I'm getting ahead of myself, second reading of the 3 bills of which The three bills, the Proceeds of Crime Amendment Act 2019, the Terrorism Prevention Amendment Act 2019, and the United Nations Security Council Resolution Implementation Act 2019. I ask, Mr. President, that the bills be read a second time.
Question is that the bills be read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Amend the Proceeds of Crime Act, read a second time. A bill entitled An Act to Amend the Terrorism Prevention Act, read a second time. A bill entitled An Act to Amend the United Nations Security Council Resolutions Implementation Act, read a second time.
The Senate will now resolve itself into a committee of the whole Senate to consider the bills clause by clause, and they'll be considered, as mentioned, first, the Proceeds of Crime Amendment Act 2019. The second will be the Terrorism Prevention Amendment Act 2019. And the third, of course, is the United Nations Security Council Resolutions Implementation Act. Of the poker bill, I put clause 1.
Mr. President, there's a proposal by Senator Knight with which I'm inclined to agree. That is, as we have no amendments for the Proceeds of Crime Act, Amendment Act, that we could take the clauses en bloc.
Well, I've just had a wonderful suggestion from the president, sorry, not the president, but the leader of government business, that we take, clearly I'm very enthused, and the question is that we take the amendments to the Poker Act, Amendment Act 2019 en bloc. Those in favor? Those against? The ayes have it. We now move to the Terrorism Prevention Act. And if you'll allow me to catch up there. I put clause 1. Those in favor? Those against? The ayes have it. I put clause 2. Those in favor? Those against? The ayes have it.
Mr. President, you could take it up to clause 7, where we have no, the First Amendment is in clause 8.
I put clauses 3 to 7. Those in favor? Those against? The ayes have it. I put clause 8.
Thank you, Mr. President. Mr. President, in the new section 14B, big B1, an amendment is being proposed, which is to delete the word or, appearing after the words Financial Investigations Division, and to substitute therefore the word and. This is where the application can be made. It states that it can be made by either, but it should be made by both, given the importance. This is the designation section, to ensure a more robust approach.
And that's to clause 14.
This is to clause 8. Right.
I put the amendment to clause 8. Those in favor? Aye. Those against? The ayes have it. I put the amendment to clause 9. Sorry. I put clause 8 as amended. Those in favor? Aye. Those against, the ayes have it. I put clause 9.
We could go up to clause 12, Mr. President, as there is no amendment before 13.
I put clauses 9 to 12. Those in favor? Those against? The ayes have it. I put clauses 8 to 12 as amended. Those in favor? Those against? The ayes have it. I put clause 13.
Yes, Mr. President, on page 12 of the bill, which is 18A, Big 5, Sub A, Mr. President, there is a typo. The word on conviction should actually be moved to the end of the chapeau. So it should read, and is liable on conviction. On conviction dash. So then it would read before, on conviction, is liable on conviction, A, before a judge of a parish, and B, on indictment before. So it is to move the words on conviction to before the dash and after liable.
I put clause 13. I put the amendment to clause 13. Those in favor? I put clause...
1 second, Mr. President. I would just want to address a point made by Senator Knight. His query was what was the sanction if the fine that was levied were not paid. And the guidance that has bine provided is that the sanction is actually in 18A6, which is where the competent authority can take action to suspend or revoke the registration or license of the reporting entity. So that it will be unable to operate. That is that is what has been proposed.
No, because, no. What would happen there is that the court would have said there's a fine of X. And it is ignored. It is ignored. Whether or not you're going to be suspended, so. You must pay it. You must pay it. Or face some other, you you either pay it or go prisoner. The principal officer go prisoner or something. Yeah. Yes, 6 stands on its own,
Because of the conviction, they can do that.
Exactly.
Once there's a conviction,
Once
the
there's a
suspension
conviction.
exists. I don't know why I recall having heard that. Can we suspend on this point?
Yeah.
While it's looked at a little further and we continue with the rest and return to it?
Yes.
I put clause 14. Yes? Those in favor of the amendment? Those against? The ayes have it. I put clause 14 as amended. Those in favor? I put clause 14 and it has passed. So there's no amendment. Thank you. I put the title and enacting clause. Those in favor?
Thank you, Mr. President. And thank you, colleagues, for the suspension. So in terms of the proposed adjustment to the memorandum of reasons, it's being proposed that after the words international obligations, we would start a new sentence. The amendments are intended to strengthen the domestic framework for combating domestic terrorism and demonstrate Jamaica's commitment to cooperate with its international partners in the fight against terrorism.
But something slipped my mind. Jesus. What number? There's a section, you see. There is a clause which deals with, which says, what it said again? For the avoidance of doubt. Which clause was that? For the avoidance of doubt, where it says what facilitation means. And it says, oh yes, could I ask, right.
Sorry, while you're reorienting, Senator, I just want to correct, just to make a little adjustment. It's not to say, and for the record, that it would be the domestic framework for combating the financing of terrorism,
yes,
and demonstrate Jamaica's commitment to cooperate with its international partners to fight against terrorism.
Exactly.
Yes.
Because that's what it is. If we could recommit clause 6, and where it says, for the avoidance of doubt, facilitating terrorist activity includes leaving or attempting to leave Jamaica in order to facilitate or commit terrorism offense. Well, why did my mind jump? Oh, I thought, President, Chairman, seeking the recommittal of clause 6.
We have no objection, Mr. President.
The question is that clause 6 be recommitted. Those in favor? Aye. Those against? The ayes have it.
Thanks. My mind jumped, and I couldn't close this aspect. It speaks to leaving or attempting to leave Jamaica in order to facilitate or commit a terrorism offense. Suppose there's someone coming to Jamaica in order to facilitate a terrorism offense. What happens? Because you see, the person would not have committed. In A, I noticed they say for facilitating includes leaving in order to facilitate or commit. I don't understand what that one really is, to tell you the truth. Because if you commit a terrorism offense, facilitation does not come into play. You have completed the act. So I don't know why the committee is there, and I don't know why, in terms of Jamaica, if there's some other legal principle that guides the thinking that has escaped me of coming into Jamaica to commit. Bec- yeah. Hmm?
What are the elements of the commit to facilitate?
It's like them trying to finance it, bring.
This could be used on case of mental health.
Him not do that.
So an accusation will be made.
We apprehend them at the airport.
Yeah.
On foreign intelligence. And they are now within our jurisdiction, but they have not committed an offense in our jurisdiction. They're coming here to facilitate. You see the danger with attempting. No, it's attempting must go to the penultimate act. And arriving is not necessarily the penultimate act. So you might find that, because remember, attempting is an inchoate offense, is an incomplete. Yeah. That's an offense.
And they returned,
That's
then
an
they would be
that's
prosecuted
an offense
there.
committed elsewhere.
There.
But if, for example, the person is living abroad but a Jamaican citizen with a Jamaican passport, and is coming in, that person now, you would have to go through an extradition process to be sent back. Yeah.
You finished, KD?
Mm-hmm.
Chairman,
Senator Brown.
yeah, just our concern, and probably the minister and our team can help us. Section 6(3)(a). There was in 2015 a case of a teenager, Akeem Hunter, who was wrongfully accused of going to join a terrorist organization. He was on his way to the Netherlands to visit his relatives and had to go through Turkey. I think I saw recently in the media that he's still seeking justice after that terrorist label. Is this opening the door for more cases of Akeem Hunter? And how do we protect the Jamaican citizens who genuinely travel in the various routes to Europe or anywhere else from just being pulled over and labeled terrorists? Because what this says is leaving or attempting to leave Jamaica in order to facilitate or commit an offense. So if you're going to Turkey and the security force say, we deem that you are going to commit an offense, or does the citizen disprove that?
I would hope that with the authorities would have at least some kind of substantive evidence. I would hope they would have something else than just the fact that you're leaving.
That's all they did to Akeem Hunter.
No,
And I don't think Akeem.
That's not.
I don't think Akeem Hunter is going to get from the DPP and ministers of justice the same treatment that they demand of others, for others. So the Akeem Hunters, for me, need protection. And so I'm asking, in light of what we're putting here, how do we protect our citizens from wrongful allegations and wrongful arrests, which could destroy their life forever? There is a Ted Kennedy in the United States who was on a stop list. And the senator, the lion of the Senate then, was stopped various times. And he was a brother of a president. So I just want to find the protection for Delroy cousin and my cousin, who and yours too, Sinclair? I don't know yet because I'm concerned about just how loose this is and how easy it is to label our people.
But it doesn't appear to be loose because you're only reading the leaving or attempting to leave. There must be something else that goes. It will require
I don't
more.
know what are those elements.
It
What
will
are
require-
those elements?
But it will require more,
not-
Senator Brown.
There is none
That
of those
speaks
elements.
to facilitating or committing a terrorism offense. It will
Hakeem
require
Hunter
more.
case, all happened is that he was going through Suriname.
You cannot say that.
No, what do you mean?
How
I can't?
can you
I'm
say
saying
that?
it. So may I be allowed to finish? In the Hakeem Hunter's case, he was going via Trinidad to Suriname to the Netherlands through Turkey. All security forces pulled him.
But
Is
Senator
this
Brown,
a
Senator
matter in
Brown.
court?
Sorry,
Is
no,
this a-
But Senator
is
Brown,
this a
I understand
matter-
what you're doing.
Is this
No,
a
what?
matter in court?
Sorry?
Is this
no,
a matter
it's
which
so-
is in court?
No, it's
You
not
just
in the
said
court.
he's
It's not in
seeking
the court.
justice.
It's not in the court
But
because
Senator Brown-
he was. Sorry, let me finish now.
How is he seeking justice?
Because the label that the government put on him, the government agency, the prosecutorial agency put on him, still stick on him now, and he wants
what-
that clear.
So it's in court.
It's not. What is
Senator
in
Brown,
court?
Senator Brown.
This is
But
a matter
no,
you cannot treat
there's
with
no
these matters
criminal
so
charge.
lightly.
There's no criminal charges.
I'm
There
looking-
doesn't have to be a criminal charge facing him
Just-
once
just-
the matter is being
So we're not
considered by
going
the court.
So,
I think this
no,
is
no,
not
no, hold on.
appropriate.
Just
Let's
Sister
take
Leader.
Hakeem out. How do we protect young people who get caught by our overzealous security force because somebody going to Turkey? Maybe to go play professional football. So I need protection for the people. What are the elements?
Mr. President, these matters are
facility-
dealt with very seriously. They're not taken lightly, and when these arrests or charges or are made, they are matters which are dealt with seriously. We have international arrangements with information sharing between jurisdictions. These matters are not done without investigation. The offense is not an offense of going to Turkey. You know, it's not an offense of leaving, of going to a jurisdiction. There are many considerations and deep investigations which are taken before actions are here. But one also has to recognize the very nature of this legislation. It deals with terrorism. It deals with terror. This is, I think, you know, one of the most serious types of crimes in that they
Why would you say that?
it is the type of crime which seeks to use the innocent to make points, Mr. President. And I think the insidious nature of this type of crime requires also a type of intelligence and a type of acting on intelligence which perhaps transcends the normal standards of crime fighting. So I think we just have to recognize that the language that is provided is not light language, and it does not permit or does not encourage abuse, but it is certainly the government, in implementation of its laws, must always ensure that the human rights of its citizens are protected, and one would hope, expect, and trust that the authorities which exercise the rights provided under this law would exercise the rights appropriately. Thank you, Mr. President.
Senator Brown, I hear your concern, but having lived in a country that went through the LTTE, the Tamil issue, from there across to India, in what happened in Bombay, in the hotel bombing, looking at 9/11, and across the Middle East. When you make laws like this, they can never ever be perfect, that someone, like even a Senator Ted Kennedy, will not be caught up in it. What you want to do is to make sure that you have an overall ecosystem or legal ecosystem will give people a measure of fairness and relatively quickly. So even a case that you might bring, you will see that it moved expeditiously through the system. We are not in a position when you're dealing with terrorists who do not plan and expose their plans to you, that you can cover everything, but we must have an ecosystem that is fair and just and relatively quick, so that if somebody is caught up as you rightly fair, then there is a measure of fairness that can get them out quite quickly. But you can't make a law that is perfect. Senator Brown.
I'm not asking for perfect laws. I'm asking for laws that take into account our citizens, especially our poor citizens. And I have seen the absence of perfect laws leading to the death of Ghana Barrett, Michael Deans, Clark, and others in custody. In this case here, this young man on his way, legitimate business, wrongly accused, 4 years after, no compensation. And I want to know, I'm not just going to sit. Let me finish up, please.
No, with the greatest respect, my friend.
Let me finish.
Can I just guide you on something?
No, let me finish.
Senator Charles,
Let me finish. I'm on the floor. I'm recognized by the
but you're
chairman.
going into a matter
I am recognized
which is
by the
still,
chairman. I am recognized by the
the
chairman.
matter is still being dealt with. The
By
young
who?
man, you want to help the young man. I understand that. What I'm saying to you, he himself has indicated, and if you Google it, you'll see that he is seeking certain compensation in the courts. You're not helping him right now by bringing up his case in this forum, because it is not a forum where the case should be brought up. If you want to treat with what can happen, deal with it in a hypothetical way. Stop dealing with his case while it is in court. It's not
You are
something
the
that's
one
going
who
to
took
assist him.
into his case. My concern
Sen-
about
Sen-
young
Sen-
people,
no,
it's
Senator
about
Brown.
the citizens of Jamaica. It's
Senator
about
Brown, Senator Brown, just yield. Senator Charles.
I'm talking about the citizens of Jamaica.
Senator Brown, can you just yield for a second, as a courtesy? One second. If the matter is sub judice, please, then let's not refer to a matter that is sub judice. Just let it be. If you have to talk about an issue, then talk about an issue in the general sense.
Which is
But
where
Mr.
I'm
Chairman,
going,
but
President. I use
Mr.
that
Chairman,
case.
what I'm asking of Senator Brown, because he has repeated himself over and over again.
But that's what repetition.
Yes, but I want to hear the recommendation that he's making for the amendment. No, not just to say that it is to protect so and so. What is the recommendation?
He did say he didn't have one, which is where I'm coming next. I was going to ask.
But after 5 minutes, he must have one now.
All right, so Senator Brown, you have back the floor to present an alternative if you have one.
I believe 6(3)(a) should set out the elements which would constitute a crime, which goes beyond just leaving. Let me finish now. Leaving Jamaica, because it could be that I am on my way to Turkey, and because Turkey is close to zones in which terrorists operate, the police conclude that and lock me up for leaving to Turkey. I want to make sure that the citizens need to do more than just going to a particular country that represents the offense, the elements of the offense.
Chairman, I understand the concern raised by Senator Brown. Maybe the answer lies in the fact that the offense is not of leaving or even leaving too. It's for a particular purpose. So the elements of the offense would include to facilitate, to do some act, or if you commit. So if they don't have the supporting evidence, then that is what gives rise now to civil action.
Civil action, you say?
That is the remedy you're going to get, because you're going to have, and I understand why Senator Brown is saying this, because you want to tighten it, because civil action comes after criminal exposure, which was not to have been. And civil action can also create some other difficulties. But I think that because these would be a part of the elements of the offense, I don't think a legislature can go further. It now gets into the operational alarms now for them to be, regard this faithful to the provisions. I was just thinking that on the same issue there, why is it not leaving or attempting to leave Jamaica, or coming into Jamaica, or attempting? Oh, you have a wording?
Just to, do it.
Report back to Senate resume on it. Is this okay?
Mr. President, I do report progress and seek leave of the Senate to sit again.
The question is that the Senate should sit again to continue its business today. Those in favor? Those against? The ayes have it.
Mr. President, I now move for suspension of standing orders to allow the Senate to sit beyond 1:30 to complete the business of the day.
The question is that the standing orders are being suspended to allow the Senate to sit beyond 1:20. Those in favor? Aye. Those against? The ayes have it.
Thank you, Mr. President. Mr. President, just to add to the point being made before, that this section... Oh.
The agenda, if you're going to paint the executive and the agenda short, to stay there all night.
The Senate will now resolve itself into a committee of the whole, not the whole.
Thank you, Mr. President. And just to thank Senator Knight for having shared his perspective on the clause, and it is exactly how we understand it to operate as well. And that is the line that one would draw between the operational elements and leaving the clause broadly enough for its effectiveness. And just to add that this section has, in fact, it was taken from the Canadian law, and it's actually been tested in their courts as well, because similar issues have arisen, and it has found to stand scrutiny. But I just want to direct the Senator Knight's attention to section 7, to clause 5, just before, which is inserts the words entering or remaining. Before the words entering or remaining, the words leaving or attempting to leave Jamaica. So it follows that entering or remaining in any country, or entering or remaining in any country for the benefit of, at the direction of, or in association with a terrorist group. So it's actually the concern which you raised, Senator, is actually addressed in this clause. So
Okay.
this is in the Principal Act 7, 3D. 73D. So it is provided for that if they enter for the purposes of. So this new element, which is leaving or attempting to leave, is to address the
I
foreign
see.
terrorist fighters,
Yes.
which is a development that has happened since, a phenomenon, let me call it, since the passage of this act.
Yes.
So entering or remaining was actually the
Yes.
original offense,
Yes.
and it is now being supplemented by the act
the
of leaving.
Yeah.
So you're, it's good that you raise the concern because it's allowed us to elevate it and to ensure that this FDF, our efforts to ensure that the Jamaican borders are being treated seriously, both incoming and outgoing.
Yeah.
And that is done by this amendment here in Clause 5.
And just to allay some fears, the offense here now of leaving or attempting to leave would actually be committed in Jamaica, so that Jamaica has jurisdiction over that. So, for example, the guy in Suriname, going to Suriname, it would be a different situation. Once the authorities here have the information and you are leaving, then they hold you here and your tribe here and so on. Jamaica has full jurisdiction.
To buy a ticket to certain place and become a suspect.
Mr. President, if Senator Knight is satisfied with the provision in Clause 5, then we could actually move,
Sure.
and having taken the amendment to the memoranda of reasons, we could close the committee's treatment of this bill, Mr. President.
And in terms of the other one,
We still have the next one.
the penalties. Let me tell you, I was looking at the parent statute, and it also treats with it that way. But I think generally, where a body corporate commits an offense, what the case name, Owens versus National Coal Board or something like that is the case, then there are specific procedures for dealing with a corporate body in those circumstances.
There are, but also just a reminder that Section 195 of the Judicature Parish Court Act provides that the parish court to apply, in order to enforce payment of a fine, to apply, to order rather the offender to imprisonment with or without hard labor for a period not exceeding 6 months if
Okay.
they do not.
Fine.
And of
So
course,
there's the other.
yes, I knew there was something that
There's the other.
would have addressed the issue. And then the Interpretation Act deals with the corporate aspect of it
Yeah.
as well.
And the DPP can give permission to.
So, Mr. President, we could complete treatment of the clauses of this bill, that is of the Terrorism Prevention Act, so that we could proceed to the UN.
I put the clause, I put the title and enacting clause. Those in favor? Those against? The ayes have it.
Thank you, Mr. President. Mr. President, for the United Nations Security Resolution Implementation Act, the only amendment of which I am aware, and I just look across the aisle to see that there is no other amendment being proposed. Just saying where we can, that we could take it, take clause 2 rather. The first one is in clause 3, so.
I start off with clause 1 or clause 2? Because I have to start with clause 1. I put clause 1. Those in favor? Those against? The ayes have it. And then your suggestion? Clause by clause. I put clause 2. Those in favor? Those against, the ayes have it. I put clause 3. Those in favor?
Thank you, Mr. President. In clause 3, there are two amendments. One is in the amendment to section 3 at paragraph A to delete the reference in the amendment to subsection 1 to subsection 2B. We're to delete subsection 3A and replace it with subsection 2B. Also, Mr. President, we are seeking to delete the word not in the same section 3 of the Principal Act, but at paragraph C, that is in the inserted subsection 2B, to delete the word not where it appears. And this actually addresses the matter that we were treating with earlier, that the objection should not have been, if an objection is not made, Mr. President. Let me just make sure it's read clearly. Yes, Mr. President, on page 3, in 2B, the new 2B which is being inserted, we will, in the third line, we'll delete, after the words exceptions shall, we'll delete the word not. And again, that's before the words take effect. So the word not in between exceptions shall and take effect is being deleted. That's on page 3 in 2B. Yes.
Shall take effect
unless an objection is received from the relevant committee. So it was that not was not in the right place. So if that can be deleted, Mr. President, those are the two amendments to clause 3 of the bill.
I put clause 3, the amendments to clause 3. Those in favor, aye. Those against, no against. Put the clause 3 as amended. Those in favor? Those against, the ayes have it. I put clause 4.
I'm not aware of any other amendments to the bill. There's no other amendment before we get to the memorandum of reasons. So if you could put the remaining clauses.
I put clauses 4 to 7. Those in favor? Those against? The ayes have it. I put the title and enacting clause.
Mr. President, if we could address the matter of the memorandum of objects and reasons. And this is to add another sentence after the words United Nations, full stop. It is to add, the amendments are intended to strengthen the domestic framework for combating the financing of terrorism and demonstrating Jamaica's commitment to cooperate with its international partners in the fight against terrorism and proliferation.
I put the amendment as just read. Those in favor? Those against? The ayes have it. We have an extra vote in that. It wasn't entirely necessary, but here we have it. Just to make sure here. The question is that I do report the bills as having passed committee stage with amendments. We passed that. I got my solid ayes and no nays. We moved on, Senator. So now we're... So no. I got nothing all day, all right, so I got a clap. The question is that I do report the bills as having passed. Okay. Clerk, we're still in committee?
Mr. President, before we rise out of committee, might I ask for recommittal of the Terrorism Prevention Amendment Bill 2019?
Those in favor? Aye. Those against? The ayes have it.
Thank you, Mr. President. Just in clause 13, the amendment of the new section 18B1, we had discussed in debate that we would delete the words supervisory authority from 18B1. Yes, Mr. President, I just wish to move for that amendment now. Thank you. Terrorism Prevention Amendment Act.
Do you hear the motion? Those in favor? Those against? The ayes have it. Yes. This one. This one. Oh, so this without? This with how many? 2. This with 2. Okay. The question is, we need to go back, move the Senate back into session. Madam Clerk? Yes. Marshall, please. The Senate now resumes its formal sitting, its normal sitting, and the question is that I do report the bills as having passed committee in the following session, in the following fashion rather. The poker bill passed without any amendments. The Terrorism and Prevention Act passed with 2 amendments. And the United Nations Security Council Resolutions Implementation Act passed with 2 amendments. I still have to get my vote, so those in favor, those against, the ayes have it. I do report the bills as having passed committee stage without amendment, as I said before. Minister.
Thank you, Mr. President. Mr. President, it having been an excellent day, it is... I also want to thank Senator Knight for his commendations, which are well received on behalf of my ministry, because certainly a lot of work has gone into this matter in respect of, and of course, in respect of the other. Now, we passed 3 bills, Mr. President: the Terrorism Prevention Amendment Act 2019, or rather, we have just addressed in committee Terrorism Prevention Amendment Act 2019, the United Nations Security Resolutions Implementation Act, and the Proceeds of Crime Amendment Act, all 2019. I now ask, Mr. President, for 3rd reading of those 3 bills.
The question is that the bills be read for a 3rd time. Those in... You're going to read, Madam Clerk? No. Just go straight. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Amend the Terrorism Prevention Act, read a 3rd time and passed. A bill entitled An Act to Amend the United Nations Security Council Resolutions Implementation Act read a third time and passed. A bill entitled An Act to Amend the Proceeds of Crime Act read a third time and passed.
Thank you, Mr. President. And Mr. President, just before we close, I just wish to express on behalf of this side to add our voices to the sentiments echoed, or rather stated earlier, shared earlier by Senator Knight in respect of the passing of Congressman Elijah Cummings. He was indeed a great friend of the Caribbean, a great friend of Jamaica, and a great believer and advocate for the rights of the downtrodden, the rights of African Americans, and of course for the upliftment of all people. He was I will indicate that the Prime Minister not only wrote his widow to express condolences on behalf of the government and people of Jamaica, but also wrote to the Congressional Black Caucus, now chaired by Congresswoman Karen Bass, expressing our sympathies and, of course, our trust that they will continue his work in upliftment and advocacy and the development of people of color and people in vulnerable situations, Mr. President. So we share the sentiments uttered earlier, and we wish to just place them on the record for this side as well. But it is not, Mr. President, intended to do any further business today. I know, I wish we had more business to do. I actually do. But there is much to do ahead of us. So I ask that the Senate be adjourned for a date to be fixed.
The question is that the Senate be adjourned for a date to be fixed. Those in favor? Those against? The ayes obviously have it.
When we the people speak out, changes happen.
True thing. I remember how we women speak out hard to get maternity leave.
Our voices and letters supported the formation of Indigo
To deal with the protection of citizens.
Vex, and we'll speak up loud about the Riverton fire. And them have to change the leadership.
People, we need to speak out more. When we speak out, every government have to listen.